Well, hello, this is Merideth Nagel, and today we're going to talk about powers of attorney. Some of the uses of the powers of attorney, some of the misconceptions of a power of attorney. And I hope by the time that we're done, I've answered your questions. But if you ever have any more questions, know that you can always reach us. You can call me on the phone at 352-394-7408, or you can reach out to us on the web at mnagellaw.com. So without further ado, powers of attorney. A power of attorney is a document that you sign naming someone else to handle your business and personal affairs. There's a common misconception that a power of attorney only comes into play if you're sick or incapacitated in some way, unable to handle your affairs. It's true that in the past, those types of powers of attorney could be drafted, but we had a change in the Florida law, and after 2011, a power of attorney is effective the moment that it's signed and then can continue throughout any incapacity. So it's a very powerful document and something that you're going to want to, of course, keep secure so that it can't be misused. So another misconception is that you can use a power of attorney to handle the affairs of the principal, that is the person who's named you as a power of attorney. There's a misconception that you can use that power of attorney to handle the affairs of the principal after the principal has died. So it is not uncommon at all for me to interact with people whose spouse or a friend or parent has died, and they're attempting to administer their estate or handle their business affairs after death using the power of attorney. Well, the truth is the power of attorney dies when the person who gave it to you dies. It becomes completely ineffective on death and cannot be used at all, whether in a real estate transaction, a business transaction, banking, for any purpose. Generally, there are two types of power of attorney. Generally, we have our broad general power of attorney, which gives very broad rights, sweeping rights to whomever you name to handle your business affairs. So you can draft a power of attorney that lets them do everything on your behalf, talk to the IRS, talk to your banks, talk to Medicare, Medicaid, insurance companies, and the like, so that they can act as you in every single way. Or you can do what's a limited power of attorney. The limited power of attorney is what it sounds like. That is, it's limited. In that power of attorney, you will name the very specific rights that that person can exercise on your behalf. So for example, if you want to have someone be able to handle your banking for you, but perhaps not talk to the IRS, we can say that in a limited power of attorney. We can make whatever limitations that you want to make. We see a limited power of attorney being used a lot in real estate transactions, so that if it's inconvenient for you to go to your real estate closing, you can name a friend or your realtor or a family member to go and sign those documents on your behalf. And we can draft that power of attorney to be that specific. Frequently in a real estate transaction, if there is a lender involved, even if there is a general power of attorney, they're going to want to see a limited power of attorney that will address this specific property that you're trying to convey or buy. It's also important to understand that when you're signing this power of attorney and you're giving these broad rights, that person can do everything for you, and that includes steal from you. So if you choose unwisely, that person could then go to the bank, clear out your bank accounts. The bank would have no liability to you whatsoever because there was a power of attorney that person used. And so your only recourse, of course, would be to sue the bad guy who's already spent your money. So it's a great document, but it's a document that must be used and wisely and kept safe. So if you have any questions about powers of attorney, please give us a call. Many of you might have what we called in the old days a springing power of attorney. That is a power of attorney that only goes into effect if you're incapacitated or unable to handle your affairs. Well, after 2011, those types of powers of attorney are no longer valid. So you may want to, if you have one, you may want to pull it out, take a look at it and see what it says, and get a new one. If you have any questions about this topic or anything else related to real estate law, title closings, those kinds of subjects, please give us a call. We'd be very glad to help you. We draft these powers of attorney routinely. They're an important part of your estate plan, an important part of taking care of your affairs, because you never know when you're going to need it. That's the problem. By the time you're in the car accident and you need your children to take care of things for you, that's too late to realize you need the power of attorney. So take a look at your estate planning, see how old it is, if it accomplishes that power of attorney, accomplishes what you want to. If you need a new one, give us a call, or if you just have questions about the one that you have, we'd be glad to help. I can be reached again at 352-394-7408 and on the web at mnagellaw.com. Thank you so much, and we will see you next time.